Okay, guys, I'm attorney Michael Redden, and I'm here for another episode of Wealth Preservation TV, where we talk about all things that preserve your wealth from creditors, predators, death, anything of that nature. And today's topic is one that's a pretty common one. A lot of people include in their wealth preservation, in their asset protection, in their integrated estate plans, an asset protection trust. And an asset protection trust is just a trust, it's just the same name you're thinking about. You're putting in this type of trust because you want to protect these assets from anyone but you being able to get inside and get them. You don't want it to benefit anyone but you. But the first thing we need to know and need to talk about before we even start talking about this particular strategy is you have to do this before there's a problem. And we say this just about every one of our videos. Remember, planning for this kind of stuff must happen before there's a rainy day, before someone sued you, before you get behind really on those bills. If you can really see in the future that there might be a problem, then you can't do it because it'll be a fraudulent transfer and you'll just make the situation worse. And of course, we're going to talk about the second issue. You don't want to put everything you own into these things. If you put so much into one of these trusts, because remember, these trusts are not you, that you're now insolvent, that you don't have enough money to make your bill payments to take care of yourself, then the court's going to say that's a fraudulent transfer too. You deliberately went in there and made it impossible for you to pay your creditors. What these strategies are about is taking the money that you don't need to pay your everyday bills, that wealth you're accumulating, and putting it someplace safe. And you've got to do it in those kinds of instances. And remember the overall theme when it comes to asset protection. We're going to separate you from your money and your money from you, so that when there's a problem with you, there's not a problem with your money. And it's going to be the same thing for your business. We're going to separate you from your business and your business from you. So when there's a problem with your business, there's not a problem with you. When there's a problem with you, there's not a problem with your business. So now that that's out of the way, we can talk about asset protection trusts. These things can happen in just about every state, okay? There are a few states that have special statutes that make them really attractive for this. The top three are Alaska, South Dakota, and Nevada. These states have passed actual statutes saying, hey, there's a special type of trust we're going to make. And when people put stuff in there, after a certain period of time, creditors can't get at it. In a lot of cases, you can't even get in there for divorce and things like that. And Minnesota is one of those states where you can't get in there for alimony or child support. There's another thing you should know too. These things come in two varieties. They come in what's called self-settled, where you make it for yourself. And that is what most of those states who pass the statutes are about. If you make a trust to benefit you to protect your assets, then it needs to be in one of those states. In Minnesota, if I made a trust for me, then I can automatically get, my creditor should automatically get into it and take those kinds of things. So you've got to keep that in mind. If you want to use one of those trusts in another state, then either someone has to make it for you, you have to make it from someone else, or you don't put things like real estate in it, okay? Because real estate exists in the state where it's at. And if you put a Minnesota piece of property into one of those trusts, then more than likely the court's going to go in there and say, hey, it's here. I got jurisdiction over that, and let people take it. Another thing to remember about this stuff too is you always want to plan to protect most of your assets, but not everything. If we were to be able to arrange something so if you got sued, nothing could come out to your creditors, then you're giving a court an opening. The court's not going to be as sympathetic to your creditor if they're getting a slow trickle of a little bit of money over years as they are when they say, hey, I can get nothing from these guys. What about these other creative theories that let me get into the trust? You don't want to give a judge or put a judge in that position, give them that opening, or give the plaintiff that opening. So with that said, let's kind of talk about these trusts. Generally speaking, if you want to make one of these trusts, it's going to have that spendthrift clause. No creditors can get into it. And it's going to be fairly solid. The other thing you want to look at for people like Minnesota is to have someone else make the trust for you, or you make it for your spouse. That's called a hybrid asset protection trust, where you've made it for someone else, but you also kind of benefit, right? You benefit from everything that your spouse has. And I know some of you might be thinking, but hey, I don't want to give her everything. I don't want to give him everything. What happens if we divorce? Well, we're not going to say, I want the beneficiary to be my wife, Jenny, or my husband, Bob. It's going to be whoever I'm married to and living with at the time. So if they leave the marriage, the trust stays with you. And a lot of times this makes it a lot easier because, remember, this is not a part of the divorce estate. They can't get in there. And should you ever need to get back into it, these trusts are built so that we can make a part of it accessible to you. That part's accessible to your creditors at that time. We may be able to terminate the trust at that time. But while you're married, that usually is the best way to go, especially in Minnesota, unless someone else is willing to make that trust for you. And you can do those kinds of things to make them for you if you have business partners. Both business partners can make the trust for each other and start putting things in and moving around that way. And that is how you provide that kind of protection. That's the basics of an asset protection trust. It's a trust that creditors can't get into. In Minnesota, it really should be settled by someone else. But if you want to put it in another one of those states with those friendly laws, just keep in mind that if the actual asset is in one of the states that doesn't have that trust, there still is an element of risk. Doesn't mean that you're going to be a soft target. Doesn't mean that the creditors are really going to find you attractive and go after it. But that's the case. That's kind of what happens. They get to choose what they want to go after, and they may try to go after that because the only thing you left them, or it's the only way they're going to collect, unless they want to wait for 20 years. And that's kind of another thing to look at too with this. There is no miracle plan that is foolproof. Okay, you still have to do trust formalities and do these kinds of things. Additionally, there could be other concerns. There could be a change in federal law, a change in law after that, and the other part is federal claims. The federal government does not have to, in some instances, respect state laws. They could come into that trust. The IRS is a really big one that likes to do those kinds of things. So you really need to kind of look at those things and keep that in mind. We can make you as hard a target as possible, but with an asset protection trust, nothing's going to be great. Unless you find the IRS, well, things are going to be great. They're just not going to be as, bulletproof. Unless it could be the IRS, or you might find that particular litigant who just doesn't like you, has millions of dollars, has a bone to pick and an axe to grind, and they're going to come after you with everything they've got. They're going to get less than what they normally would have gotten, but at some point there's going to probably have to be a settlement, or they're going to take it all the way up, and we don't know what's going to happen sometimes when that happens, right? There's all those creative kind of strategies that go through with it. But for the most part, people who have these plans discourage those lawsuits. Okay, most of the time the lawyer who's suing on behalf of the plaintiff is on a contingency. He doesn't get anything unless they get paid. And does he want to go and foot out a couple $100,000 in the chance of getting more? Is he able to do that? So, you can see that it's going to protect you from the vast majority of claims. And so it's a really good strategy, and most people who are high net worth, who have things to lose, should really be considering these strategies.